This is Michael Osterling. I'm speaking with Bruce Fein, constitutional scholar. Bruce, we were just talking about KORUS, the Korean Free Trade Agreement, which has not been ratified by Congress. And I asked you whether you think the authority that the Korea Free Trade Agreement gives to foreign tribunals, either run by the UN or the World Bank, to determine U.S. law or even state law if a Korean company decides to take us to court, is constitutional. And you said no.
Yes. That's because, Michael, it's Article 2 of the Appointments Clause, and the Appointments Clause basically designated how officers of the United States may be selected by the President. Sometimes it can be unilaterally, sometimes it requires Senate confirmation, for example, a Supreme Court justice or an ambassador, and Congress can occasionally choose between those two. But the critical element is an officer of the United States, and the U.S. Supreme Court said an officer is anyone who exercises significant enforcement authority under United States laws. And what you've described is a tribunal, a foreign tribunal, that will be interpreting our countervailing duty laws, dumping laws. These are terms of art in the world of international trade. And yet they're not appointed by the President. There's no congressional involvement whatsoever. They aren't ratified or confirmed by the Senate or the House or anything of that sort. And under the U.S. Supreme Court's decisions, it seems pretty clear that is inconsistent with the Appointments Clause. Well, but if this is part of a treaty, can you override the Appointments Clause with a statute or a treaty? And the Supreme Court has said repeatedly, a treaty cannot flout the United States Constitution. For example, if you have a right to jury trial, the Supreme Court said you cannot have a treaty that exposes you to a non-jury trial in Japan under a status of forces agreement, that the Constitution itself is above what any treaty might stipulate here. And here we just have legislation that would implement the free trade agreement, and legislation cannot violate the Appointments Clause. So now, sometimes you have difficulty in having what's called standing. Who's going to bring the lawsuit to claim that these tribunals are unconstitutional? Oftentimes there are business interests, practical interests that make it unfeasible or make private parties reluctant to bring the lawsuit. Here you might find someone who is impacted adversely because of a decree of this tribunal, say, all right, I'm being injured. But the problem you have in finding these kinds of plaintiffs is that in this very, very heavily regulated economic environment, oftentimes, if not most of the time, the perfect plaintiff has other things they want the government to do for them, other things they want the executive branch to do. And say, no, okay, I won't bring the lawsuit because otherwise they'll deny me merger that I want to undertake, they'll deny me the additional bank branch, or they'll deny me approval of a new drug, and so they basically are held up and frightened away from enforcing their constitutional rights. But my view of this case ultimately could get its way to the Supreme Court, addressing the authority of foreign tribunals to interpret and apply U.S. law with jurisdiction in the United States itself and entities. This U.S. Supreme Court would hold it invalid under the Appointments Clause.
Would there also be a 10th Amendment related issue in that these foreign tribunals can also find state laws to be invalid?
I doubt whether that's going to be a case, because insofar as these treaties, these statutes, arise under the federal authority to regulate foreign commerce, which is a specific enumerated power under Article 1, Section 8, I think that would imply the authority of Congress if it wishes to override state laws, which it oftentimes does, for example, in regulating interstate commerce. It's what's called federal preemption. And therefore, I think the 10th Amendment argument would be relatively weak.
Of course, we don't have to go there if the whole thing is
unconstitutional. Yeah, the Appointments Clause, you don't need to go to
right.
the 10th Amendment.
Great. Thank you, Bruce.